let's talk about the wide world of trial motions. A motion is just a fancy way of asking a judge to do something. Parties can file a motion requesting just about anything they want from the judge. The party filing the motion is called the moving party. There are two important ways to distinguish between different types of motions. First, motions are brought at different phases in the case. After the complaint is filed starting the case, motions to dismiss are filed. Motions for default are also filed after the complaint if the defendant doesn't file an answer. Then there are motions for judgment on the pleadings after the answer is filed. Then comes the discovery phase of the case and all of the discovery-related motions. Then, summary judgment motions are filed based on the evidence the parties got in discovery. Then right before trial, motions in limine are filed seeking evidentiary rulings. During and shortly after trial, parties can move for judgment as a matter of law. Then finally, parties can file post-trial motions because they believe the trial went wrong somehow. The other aspect that distinguishes different motions is that parties must make different showings to win on each type. Let's now talk about each motion in more detail. Now, the first group of motions are really an attempt to skip a jury trial. Now, normally in a jury trial, the parties present evidence to the jury decides who to believe, and finds the facts. In other words, writes down in a verdict which version of the facts they believe. Now, the jury serves this narrow function, figuring out what facts to believe. The judge is the one who decides whether the facts, as the jury believes them or finds them, entitles the plaintiff to win on a claim. So, the first of these motions asking to skip the jury is the motion to dismiss, also called an MTD. An MTD is a defendant telling the judge, the plaintiff has not alleged facts showing that I'm even liable to pay anything, so let's save some time and dismiss the case now. An MTD is brought under Federal Rule of Civil Procedure 12b. There are multiple reasons to bring a motion under 12b, but the most common and confusing of these is failure to state a claim under Rule 12b-6. A 12b-6 means the defendant believes the plaintiff's complaint doesn't contain sufficient facts to make each of the claims plausible. So this leads to, what is plausibility? Here, it's important to understand the difference between some terms. First, legal elements. Second, ultimate facts. And finally, specific facts. The legal requirements of a claim are the legal elements a plaintiff must prove to win on the claim. For breach of contract, for an example, it would be a valid contract, breach of the contract, and then damages resulting from the breach. Ultimate facts are the generic facts that correspond to a claim's legal requirements. So these are the generic facts the jury must ultimately find in order for the plaintiff to win. In a contract claim, the jury must find the ultimate fact that both parties agreed to a contract, the defendant did not do what was required in the contract, and some damages resulted. A specific fact is a fact that the jury could use as evidence to find these ultimate facts. In other words, these are the facts that actually happened. For example, specific facts might include that Bob and Lisa signed an agreement on July 17th for the defendant to sell the plaintiff a car for $10,000, but the defendant never delivered the car. So now back to plausibility. To determine whether a plaintiff has made a claim plausible, the judge looks to each claim in the complaint and asks, assuming the plaintiff's specific facts are all true, are there sufficient facts in here so that a jury could find those ultimate facts in the plaintiff's favor? The judge ignores any language merely stating the legal elements of the claim or stating the ultimate facts and looks just to these specific facts. Now, after taking all the specific facts together, if the plaintiff would win on the claim survives and the motion is denied. The plaintiff's claim will go on. But if the plaintiff's specific facts are not enough to make the claim plausible, such as if the plaintiff forgot to allege how the defendant specifically breached the contract, the claim will be dismissed. Now, on to summary judgment, the real workhorse of the trial courts. This motion is either the plaintiff or the defendant telling the judge, we've been through discovery, and now that we know what evidence is going before the jury, it's clear a reasonable jury could only find in my favor based on this evidence. So, to practically do this, a party requests summary judgment filing a motion under Federal Rule of Procedure 56. Rule 56 says a party should get summary judgment if she can prove to the court there's no genuine dispute of material or relevant facts, and these undisputed relevant facts entitle the party to win. So let's put this together. The moving party must explain what the law requires by citing to specific cases and statutes on point. Then the moving party must point to evidence for every fact relevant to whether these legal requirements are met. Now, because summary judgment takes the place of a jury trial, every statement the parties make about the facts must be supported by citations to admissible evidence. For example, now the plaintiff could state the parties entered an agreement and then cite to an authenticated copy of the written contract, or to a certified deposition transcript where the plaintiff admits these same facts. The judge then looks at all of the evidence cited by the parties and asks whether a reasonable jury could find for the non-moving party. If so, the motion is denied. So to recap, to win on summary judgment, the moving party first explains to the judge what the law requires the plaintiff to win. The moving party cites to cases and statutes. Then the moving party points to admissible evidence to prove what the jury will see at trial. For example, by citing to that copy of the written contract or to deposition testimony. Finally, the judge decides whether a reasonable jury could find only for the moving party, based on all the evidence, or if the non-moving party could possibly win. If a reasonable jury could only believe the facts in a way that would make the moving party a winner, he gets judgment. He wins on his claim. Or, if it's the defendant, the plaintiff loses on that claim. But if a reasonable jury could look at the evidence and believe a version of the facts that makes the non-moving party a winner, the motion loses. Now, when a moving party wins summary judgment, it is often because the opposing party has failed to submit admissible evidence to refute some fact. Other times, the moving party may win because the non-moving party admitted some fact in a deposition that makes winning the case impossible. Now, two other motions are close siblings to the motion to dismiss and summary judgment because they tell the judge there's no reason to wait for the jury to decide the facts. These are motions for default and motion for judgment on the pleadings. A motion for default is brought by a plaintiff when the defendant has failed to answer the plaintiff's complaint. After the default is entered, which basically says the defendant's given up, the plaintiff can file a motion for default judgment, basically asking to automatically win because the defendant has failed to respond. As to motions for judgment on the pleadings, the plaintiff or defendant argues that they are entitled to judgment based on the allegations in the pleadings. This could be because the defendant has admitted facts make the plaintiff an automatic winner, or the plaintiff admitted facts that trigger a defense for the defendant. For example, if the defendant admits in the answer that it breached a valid contract, the plaintiff could ask for judgment the defendant is liable. Now let's talk about a few more types of motions. First, during discovery, the parties request information from the other side so that they can build their case. There are a number of rules governing what types of things a party can request, such as a limitation that only relevant information can be requested. There are also a number of defenses, such as where information requested is privileged, or the information would take excessive time to collect. Unsurprisingly, parties often have disputes about what information or documents should be produced to the other side. If a party believes she's entitled to information the other side is withholding, she can file a motion to compel under Rule 37 and explain to the judge why the party has a right to the information and why any defenses are meritless. The defending party can also file a motion for a protective order, where they can explain why they should not have to give up the requested information. There are also motions in limine. These are evidentiary motions brought before trial to strategically figure out what evidence can get in and what evidence will be kept out once the parties actually get to trial. To be admissible, the parties must show the evidence will or will not pass a number of hurdles set out in the Federal Rules of Evidence. There are also motions for judgment as a matter of law. These are filed after the opposing party has presented their evidence to the jury. The moving party is telling the judge, even taking all of this evidence as true, the other side loses under the law. We don't need to finish the trial, and in fact, that we can send the jury home. Finally, there are post-trial motions, including motions such as a motion for a new trial or motion to amend to set aside the judgment. Parties usually file these motions because they believe there's some defect that causes the judgment to be improper. For example, a party may believe that there was a serious legal error made during trial which prejudiced the jury, misconduct by a party or witness, or a clerical or excusable mistake. This should give you a general understanding of the most important types of trial motions.